At Kroger, we want our fresh produce to meet your expectations, which is why we're dedicated to doing up to a 27-point inspection on our fruits and veggies, checking for things like scarring. In fact, only the best produce like zesty oranges and crisp carrots reach our shelves. Because when it comes to fresh, our higher standards mean fresher produce. Kroger, fresh for everyone.
Save big on your favorites with the Buy 5 or More Save $1 each sale. Simply buy 5 or more participating items and save $1 each with your card. Kroger, fresh for everyone.
Impact of influence, the Murdaugh family murders. This is the unfolding story of a powerful South Carolina family, the mysterious deaths they are linked to, and our quest to bring you the truth. Hello, friend. So grateful you're spending time with us. Murdaugh Podcast on Facebook, murdaughpodcast.com. Matt Harris, podcast@gmail.com. I am Matt Harris. Seton Tucker is here. We're both on the phone today as I am driving from Colleton County Courthouse. And Seton was there this morning and yesterday as well. John Snyder, who has been on both sides of a murder trial, both as a prosecutor and a defense attorney, joins us as well. And we will begin with Monday's testimony from the defense experts. And Seton, discuss that.
Yeah, so first we heard from a pathologist who basically, my take was he came on to say that Paul's gunshot wound came from the top of his head, disputed kind of this through the shoulder or neck up to the head. So first this pathologist came on, and then we heard from a crime scene reenactment person who kind of tried to put it all together for us.
And I think he did not put it together super well. I mean, we did get the idea that he was saying he believes that it was a contact shot to the head to Paul, which, if indeed it was, he says would have made this massive blowback where skull and brain and debris and blood would have covered the shooter, so much so, and maybe even injured him, so much so that the shooter would have been dazed and would have been not able to pull himself together or herself together to get over quickly and shoot Maggie as many times as he did. And so therefore the two gunman theory reared its head again. And of course, one of the big things was they didn't shave Paul's head to see if indeed there was the contact there, because it would have left a mark. And that is how they got back to the two shooter theory again. John Snyder, just have any thoughts on that?
So I think the pathologist is raising a valid issue because based on the injury that under their theory, if somebody was shooting a shotgun at that close of a range, the shooter themselves would have been injured. And so you would have had some evidence on the shooter through injury that proved that they were the trigger man. And so the pathologist for the defense is pointing that out to say, Alex didn't have any of this. He wasn't, his eyes weren't injured. He didn't have any scar tissue on his face from, bone fragments. There's nothing on Alec that would be consistent with a close range shotgun blast to Paul.
And they couldn't, and it wasn't just something he could simply just rinse off because it would have really messed him up.
And they brought up his thick hair. He had this thick hair, and would it be possible for him to get all the stuff out of his thick hair? Another thing that they brought up was kind of this absence of some of the blood matter where the person who was standing in the area of the shooting. So, like, obviously, if someone's shot and you get all this blood spatter back at you, there would be, if you're standing in the way, you would not have spatter around where the person was standing in the way on the walls and that sort of thing.
I think they called it a void, that
yes.
There wasn't anything there because it would be somebody there. But this question I have for you, John, and I may be going a little crazy on this. I talked to other people who were confused as to where he would be standing, the shooter, etc. And this comes into play later in testimony from the other side. But I thought it would have behooved them to have some sort of reenactment, maybe a door jam, maybe even standing up and saying specifically, this is here and how it goes. He shoots him here, he walks over here, but they never did that. It was just all talking, kind of pointing at things. Thoughts on that?
One, they may have been limited by budget since the guy's broke and that kind of stuff is expensive to produce. Two, what the defense is trying to do is to show, look, we've got a very clear and fair explanation that it was two shooters. And so if we have a very clear and reasonable explanation and they have a reasonable explanation, that's what reasonable doubt is, folks. And so the danger in going all in on a forensic approach is, what we see today with, how good is the science? And, if somebody committed this murder, I think the way they did it was they probably shot the wife first, then the son is surprised, comes out, and then he gets shot. And so, nobody's proven what my armchair theory is of how the murder happened.
Yeah, no one likes your theory.
That's what neither side is saying. Neither side is saying that. And I actually can disagree a bit with Matt because I actually thought the bringing up with the two shooters was successful. It made me personally question, okay, was there someone else there?
Yes, well, I mean, the two shooters, that part, but I didn't get how the guy got behind, the shooter would have gotten behind Paul and got the gun above him. That was confusing.
Oh, he's leaning forward. He was leaning forward.
But they didn't clearly say that because they also said the shooter stepped into the feed room. So it got confusing to me and a couple other folks. It's like, okay, well, exactly where was he?
Or they moved the body. Or they moved the body and post-mortem, they did the second shot close range.
I don't know. That's fishy. But the other thing from that day, so where do you want to go next? Your call. Where do we want to go next?
I mean, we covered both of the experts. We had the pathologist, we had the crime scene reenactment person, who I thought were successful. You didn't necessarily agree with me. And then we had John Marvin, Alex's brother, take the stand. And I will tell you, being in the courtroom, he resonated with the jurors. In my opinion,
absolutely.
He spoke for his brother, and I kind of at the end when they said, well, they talked about this family legacy, and one of the things they said, well, was your family legacy important to you and Alec and all these things? And he said, of course, but I think everyone's family legacy is important. And I saw some jurors nodding their heads.
Well, in fact, he said, just as yours is, as he said to the prosecution, and then he looked over at the jury and said, just as y'all's is. So he gave him one of those kind of things.
Exactly.
Also, one of the beautiful things he did right out of the gate is he distanced himself from attorneys. I am not a lawyer, made a little joke about it. And I think it was important that he wasn't seen as one of the smooth talking, not that he isn't smooth talking, but the smooth talking attorney types. And you know what it's like to distance yourself from an attorney, John. Right? I mean,
it's hard to do.
He was more of a manly, more of like, I do these heavy equipment and rentals and, that kind of thing. I thought he was emotional in the right places, too.
No, he seemed obviously very close to Paul and was obviously torn up when talking about Paul and his injuries and his closeness to Paul. And that it came across as genuine.
Now, that wrapped that up. And so it would be Tuesday. The defense gets to bring up the rebuttal witnesses. And Seaton, let's hit it. What do we got in the first two?
Well, I think the judge seemed slightly annoyed that the defense or the prosecution was bringing up so many rebuttal witnesses. And the first witness they brought up was Ronnie Crosby, who was a former law partner of Alex Murdaugh. He had already testified. And the big takeaway from him was Alec was a theatrical lawyer, and basically, he was a big actor, and maybe you can't believe anything he says. That's what I took up from it.
Plus, it got really fiery. Let's play a little clip of Dick Harpootlian trying to get under his skin and say, "Hey, you hated Alex, didn't you?" Let's hear it.
Withdraw the question. Let me ask you this question. Maybe this gets to the meat of matter here. Have you had to come out of pocket to pay back the money he stole?
Yes, and
how much? And don't tell me you don't know.
Well, we're still counting, Mr. Harpootlian.
Well, how much have you paid so far?
We have had to borrow millions to pay back.
No, how much have you had to come out of pocket?
Well, when you borrow it, you got to pay it back, and I couldn't tell you how much has exactly been paid back as of we sit here today. But yes, and if you're implying that I would come in here and somehow shade truth in any way because of that, I would take high offense with that, Mr. Harpootlian.
I'm concerned about your high offense. Are you angry at him for stealing your money?
I have no feeling one way or the other.
You don't have any feeling about Alex Murdaugh betraying you and stealing your money. I admire you. I don't know that I can look beyond that.
Objection, Your Honor. Objection. It's sustained. There's not a question. The jury is to disregard the argument.
You are not angry with Alex Murdaugh?
I have had anger with him, extreme anger, Mr. Harpootlian, because of what he did to my law firm, my partners, my client, his clients, our clients, what he did to his family, what he's did to so many people. Yes, I experienced a lot of anger. But you can't walk around with anger. You have to find a way to deal with it and move forward. And I have done that. And if you suggest you are dead wrong if you think I've come in here and told this jury something because of money, when we're talking about two people who were brutally murdered, then you're headed in the wrong direction.
Do you think he did it?
I don't have an opinion. I don't have the benefit of the materials you have.
Well, let me ask you this. You're angry with him, stole millions of dollars from your firm. You admit your firm's not even called the Murdaugh firm anymore, right?
It is not. I don't admit that I'm angry right now. I told you I've gotten away from that. I don't have any feelings because you can't walk around with anger. I have been very, very angry about it because of what he's done. And he did it in a very callous way, a very deceitful way.
And you carry I'm sorry, maybe I just saw some anger there. Were you angry just a moment ago?
No, you keep trying to push a question and don't want to accept my answer, which is what it is.
That you've just given your Zen, your Nirvana, your whatever the...
Your Honor, objection.
Mr. Harpootlian,
forgiven him?
I came to the scene of these murders to support my partner. I was there. I saw things that hadn't even been talked about in this courtroom. I was there. I love Paul very much. I thought I knew who Alec was. I did not. And it's hard to you might not understand, but it's hard to walk around with anger, and hard to even walk around with it when it's with somebody who you didn't know and didn't understand. So you might have be that way, but I've got to function, I've got a family, I got to move on with life.
Okay, this was everyone. I think his mouths were dropping open at this point. Harpootlian was very fired up, and Crosby kind of gave it back to him, but he didn't go as far as saying he thought he was guilty, but obviously he's mad. John.
Yeah, rate that, Mr. Attorney.
Yeah, so a couple things I noticed, he never stopped being a lawyer, in that when he starts going through, I was mad that he did this, and then he said, my clients. And then he stopped, because I guarantee you what flashed through his brain was, if they were my clients and I wasn't managing their case file properly, I'm going to get in trouble with the bar. And so he immediately revises his statement to make sure that's the jury and everybody there knows that they weren't his clients personally. They were the law firm's clients. And so I mean, that interchange was a good interchange, and I think when Harpootlian asked him directly, "Do you think he did it?" he didn't have an answer, and so while he was keying him up on bias or keying him up on why you're just here because you're mad that you lost all this money, the guy answers truthfully, and then when he's asked, in his moments of candor, you think he committed the murder, he doesn't have an answer. And it wasn't like he ain't trying to be friends with Alex Murdaugh anymore. He's had a lot of money. So I thought that.
Who do you think wins that? Who do you think, in a juror's mind, who do you think wins it when he says, "I don't know"? Do people take that as, well, it's possible, or do they say, he doubts it, then why shouldn't I doubt it?
I mean,
No way to know, right?
It could be both. I mean, that's, again, jury decisions are sometimes like elections where, why do people ultimately vote for one candidate over the other? Or why does a juror make a decision one way or the other? It might be because they're cat people, and somewhere along the way they find out that a candidate likes cats. Or they might hear that one of the witnesses owned a cat, and therefore they're like, well, if they owned a cat, they can't be guilty. Or what? Yeah, who knows? Right now, the fact that we all are still seeing, different versions, different possibilities. Some of that's punditry, but some of that's like, hey, if the jury decides that any of the defense evidence is plausible, they're going to really hone in on the defense argument of reasonable doubt, which will then be rebutted with the closing of the state.
This jury seems so done, annoyed. They've listened to, we're now on almost week 6. They're done. Does that bode well for either side?
I think as a result of the length of trial, you're probably going to have longer deliberations than this jury could be out a lot longer than will seem normal, primarily because they're not going to remember the testimony that they heard on day 5 of somebody. And so somebody's going to have a note or remember when the guy in the with the red tie testified? Well, let's ask the judge to send back his testimony.
And I disagree with you as far as what I saw Tuesday afternoon. I did not think the jury was over it or disengaged at all. We can get into that further when we get to the testimony that really I saw them leaning forward and seemed to be really into. But who do you want to tackle next? Harpootlian's attack on
the forensic pathologist. She was called back, Dr. Reimer. And actually, I mean, as your point taken, that maybe the jury is not disengaged. Maybe they might, after hearing some of the same testimony over and over again. Dr. Reimer, I kind of think a lot of the jurors were uncomfortable because Harpootlian went pretty strong at her. I mean, he was fiery. I don't know if he was in a bad mood or what was happening today, but he was really going after her about her analysis, especially about how Paul was shot.
And I want to ask you about that, Snyder, as a tactical situation, because the appearances, or could be, and some people on social media said things about it, that this old dude is beating up on this female doctor and who is likable. And my question is, does the science get lost sometimes? And do you have to kind of pick and bob and weave when you go after, I know you're defending your client and all that, but sometimes maybe it has to be measured. What do you think?
Sometimes it's your own mood. Some days you're a little grouchier sitting in the counsel chair than you would be on other days. But with this witness particularly, I think he was incredulous of her science from the very beginning. And so the jury is going to track with him being incredulous. versus gender roles or, beating up on this girl. Like she's a doctor. She's a professional, professional. She's a professional witness. She can handle herself. I wouldn't worry too much. This isn't the first grumpy lawyer that she's ever run into.
Yeah.
And so I think the jury is more likely to not react to that, to not really even care, because the points that he's driving home are valid, which is, hey, you testified under oath that you're an expert. You are. Okay. And within your expertise, what does that mean? Does that mean that you didn't, follow standard medical procedure for performing an autopsy? Did you, she, one of the major parts of her job, along with doing medical examinations, is testifying. So I think it's probably not the first time he's ever cross-examined her. And I think they probably know each other outside of court. And so the points he's raising, I think, are points that the jury's going to consider, and they're not going to have age bias or gender bias of the witness. I think we're past that point, and should not be a focus.
Well, the two things that they kept hammering in, and again, it's now becoming this battle of experts, but the fact that she didn't shave Paul's skull to see if it was in fact a contact wound. And what was the other thing, Matt?
She didn't x-ray the brain.
Yes.
To see if it was decimated more or if there were pellets in it, things like that.
And then we heard from T.C. Smalls, who is the Hampton County Sheriff, and he testified that Alex never contacted him about installing a blue light in his car. And on cross, they said, well, maybe he contacted someone else in the department, but just another witness to kind of go against the credibility of Alex and being a liar.
Yes, that it was a small.
At Kroger, we want our fresh produce to meet your expectations, which is why we're dedicated to doing up to a 27-point inspection on our fruits and veggies, checking for things like scarring. In fact, only the best produce like zesty oranges and crisp carrots reach our shelves, because when it comes to fresh, our higher standards mean fresher produce. Kroger, fresh for everyone.
Save big on your favorites with the Buy 5 or More Save $1 each sale. Simply buy 5 or more participating items and save $1 each with your card. Kroger, fresh for everyone.
It's quick. He was up and on and off in a second, but you're right. Just a little dent into his, look, he's lying about something he didn't have to lie about is what kind of the takeaway from that is, because he never had to say that TC gave him the green light to get the blue lights. But he did, and maybe he was mistaken who said it. Next, Seton.
Paul Managal, who was previously testified as a cell phone person, and they qualified him as an expert. And then he immediately went into this test that he'd done some testing on a cell phone, which was the same model as Maggie Murdaugh's cell phone. And he did some self-testing where he threw it, and both sides agreed that he was an expert. And then he went into this home testing. Matt, explain it.
It was ridiculous. It was ridiculous. I was in the wildlife center where people that are the overflow watch it, and people laughed out loud because the guy basically like, you know what I did? I'm going to paraphrase, of course. So I have a 14.5 operating system. She's a 14, and I went into my office and I closed the door and I kept flipping the phone upside down. I threw it like a frisbee, and 8 out of 10 times the backlight didn't go on. So it could have been thrown and it would never register. But
okay, I myself conducted this test myself, and I talked to several other people in the courtroom. When this all came out, we are like, let's see if our backlights turn on. I talked to multiple people who conducted these self-tests on their own at home.
Yes, and they earlier had argued, though, that it was you had to be close to the same operating system. It wouldn't have been as sensitive. But regardless, I mean, they on cross, they're like, so did you even record this? Did you write it down? The guy's basically, I just kind of flipped it around in there and in my office, and I came close to, maybe 90% of the time. I'm like, please, this means nothing. This is ridiculous.
And there was a question of if he didn't record it, was the the question of him not recording it, because if he had recorded the results of his testing, he would have had to provide that to the defense.
Yeah, I mean, it was just, I thought it was, I'm not even sure why they put him up there, maybe just a little bit of, to show the possibility, but anybody's listening, that's got to be like, this is not science, brother.
Well, I understand why they did it, because I do feel like a lot of people, including myself, had questions about the disposal of Maggie's cell phone.
Yeah, but will it hold up if you're thinking through it? I mean, but maybe, because I've said before that they said it doesn't record any orientation, sideways or something, whatever. As long as the backlight's not on, you won't know if it's moved. So they're going with this theory now. I think it's a relatively new theory for their side, that it was thrown and it did not record when it was being thrown. This helps the prosecution, because before they were said it was being thrown at 9:08 or something, and Alex wasn't right there at that time. So they're kind of adjusting on the fly, but hey, whatever. Who next? See.
Well, we heard from Mark Ball, who is another one of the former law partners of Alex Murdaugh, and I really felt like it was just a kind of repeat of Ronnie Crosby. I didn't think it was added anything.
I didn't either. So what's next you got?
Yeah, and then we had the lunch break, and we dug into a recall of Dr. Kinsey, who is the crime scene reenactor for the prosecution.
And he was a great, great witness. He was charming. He was funny when he had to be. He spoke in his southern drawl, and I think that ingrained himself to the courtroom and to the jurors. Very likable, very affable. The jury was hanging on his words. They were laughing with him. And basically, he made the his testimony was that the defense experts that said that the shooter was between 5'2" and 5'4", and he proceeded to blow that apart by saying all the different ways that a gun could be held, or you'd be on your knees, or you just don't know, because the line the guy used was from a hole in like a cardboard type substance.
Yeah.
So it wouldn't be accurate. He just kind of tore that apart as not being probable that it was, or even if it was possible, it certainly wasn't definite that it was 5'2" to 5'4". It even went into describing how a 6'4" guy could have done it, which is Alex Murdaugh's height, incidentally.
I think he said 7. He said a 7-foot tall person could have done it.
Yeah, he just kept going. Yeah, it could have been 5'4", could have been 6'4", could have been 7'4" for that matter. So yeah, that he just disputed that. But I think where he really got some points was on the major this whole thing about the two shooters is now they're basing it on he would get hit in the face with all this bone and mass, etc. Well, he really kind of crushed that a little bit, or a lot of it, I think. He said that for him to get in a position, the shooter, where he'd be above Paul and shoot from that distance, and it was just, he did it in the door frame. He used the door frame as the entrance to the feed room, and showed how awkward it would have been for the shooter to get in a position to shoot Paul in the head. And then he went through other scientific reasons why it probably wasn't a contact shot. And if it was a contact shot, one of the big things he explained was he'd seen 36 or so in his life, investigated or seen. In fact, someone committed suicide in front of him. He says when someone does that, puts a gun to their head, or someone puts a gun to the back of their head, it blows apart their face. And Paul's face was intact. The orbital bone is kind of like paper, and it just crumbles. And so his argument was that I've never seen a face survive a shot to the head. And if it did indeed happen, the guy would have been in a really awkward position.
Well, that's what Dr. Reimer said earlier, too. She felt like if in these type of injuries, the way Paul's face was intact would not have been plausible. But when I was listening, because I was writing back and you were in the courtroom, it sounded like they opened a door to make this a visual for the jury. Did that happen?
Oh, it was a great visual for the jury. It was an amazing visual, because and like I said, it could be completely different than what the defense experts said, but the visual of the attorney trying to squeeze behind the person who was playing the role of Paul to get behind him in this little tiny doorway, get above him with a gun and shoot him, it was just ridiculous. Now I don't think he succeeded on redirect, or I guess it would have been cross, of proving that it wasn't, or he didn't demonstrate another way it could have been using the visual of the doorway. He tried. He had Dick Harpootlian go up there. He did the bend over thing. Maybe if Paul was bent over, but I just don't think it played as well visually. But I don't, let me, John Snyder, I'll bring you back in on this one because I have a question. If you think the science, let's say all the experts wash, right? You just got to have a push. Does anybody have a particular edge in that if it's a push?
Well, I mean, I think bringing in the dummy door to illustrate his testimony is compelling. I mean, why are we always trying to use the latest technology in broadcasting? The same reason in a courtroom, you always want to look like you walked off the CSI set. So the state did a very good job with this to be like, hey, we've called our witness, you called your witness, and we get to rebut what your witness just testified to. Here's this little doorway we've got. So Doc, why don't you stand over here? So based on what you heard defense's experts say, show me the angle I'd need to be at in this door frame to be able to make that shot. Okay, well, that seems improbable. Now, that may ultimately be the key sequential evidence that renders a conviction, because it isn't science nerds talking. It's them seeing the very thing. Now, I think, when y'all, I'll kind of pause here to you guys. I want to talk about the field trip tomorrow.
Yeah. When I think that's going to come into play, like they're going to actually see the literal doorway. They'll get the size of it and all that. If you want me to go right into that, I can. Okay. Well, we're good because that was about it for the day. Then he announced it's field trip time. So yeah, when that's one of the things, I think one of the first things they'll look at is that doorway.
So I personally think that tomorrow's field trip will probably be, and I don't call it a field trip to be flippant about it, but I think jurors getting to see in real time, in real space, and like you're no longer in the courtroom, you're going to get a full conceptual vision of, the defense testified that the shooter was here and shooter 2 was here on the grassy knoll or whatever their theory is. Or you're going to be like, oh, it is very easy for someone to have shot Maggie and then turned around and shot Paul, or shot Paul and turned around and shot Maggie if they were carrying weapons on them. So tomorrow will allow the jury in a more powerful way than any testimony, than any legal argument. That will be how they decide the case, because the context is it's the same reason we go to visit battlefields and historical things, because once you're there, once you see Pickett's Ridge, you understand like what the Confederate Army was going up against with the Union Army. Or you go down to Fort Fisher, North Carolina, and you see the giant mounds that were blown away by cannon fire. Like that really puts battles, crime scenes, history, anything into effect for for the jurors' mind's eye to kind of put a full picture and reach a decision.
Let me ask you: are either the defense or prosecution allowed to comment, or is this just going to be a quiet tour?
So
No, I can tell you that before, because Newman spoke to that today. No questions from any of the jurors to anybody but the judge. No comments from anybody except for the judge, and the jurors can't even talk to each other. So that's the rules.
And Newman is attending this field trip.
Yes. Is that unusual, John? Do they can't ask questions, or they can ask the judge?
no, I think that's. I mean, it is. Both the state and the defense have agreed that it's that the viewing of the actual scene is in the jurors' best interest. So they both have rested, so the jury cannot consider any additional presentation from either side. And so the jurors may have questions for the judge, and then I wouldn't be surprised if maybe there's not a court reporter also on the trip. It just in the event that a juror does something, or they need something recorded for the transcript, and then they'll address those questions probably back in court, so counsel has an opportunity to give their opinion of the question, or how they think the judge should answer it. But it is going to be basically they ride down, they walk around, they take whatever mental pictures they need to take, and then the judge will start giving instructions.
And Seaton, what do you think they would want to see most? What do you think they're going to be taking in?
I would think. I mean, I don't know. I think to make sense of Paul's body in that feed room, I think to me that would be what I was looking at as a juror. But again, it doesn't matter what I think.
I also think it'll be when you hear people talk about 30 yards or 40 yards or 20 yards. First of all, people probably, who knows if they're even accurate, but distance in an overhead drone type shot or whatever doesn't tell you the distance. And if they can see how far, I mean, obviously the places where the bodies were will not be marked, but they can remember. So how far apart were the bodies? How far away is the house? How long would it take for Ella to go from body to body, or to shoot Paul and then to walk and go over to shoot Maggie? Those kind of things are much more visual when you're there than in the overhead photos they've seen or individual photos. And I know I can't. Someone tells me 30 yards. I don't exactly know what that distance is, right? I mean, I think it's huge.
Absolutely. You're completely right. I think people really need to have a visual.
It just completely puts all the speculation, because you take a picture of a crime scene, until you've actually been out there, you don't really understand it. And going to what both of you said, which is scale. How far, was Maggie running for her life? Okay, you can then understand like the drama of the space because you see it versus a picture that has like a red arrow on it, say body found here, and little yellow markers for where casings were found and all that. I mean, all that stuff's great and interesting, but I think going to it and seeing it brings it to life and will allow the jury to have, neither side is put at a disadvantage. Both sides are convinced of the value of having the jurors going out to see this, and both sides are convinced for different reasons.
Yeah, prosecution put up a little bit of a fight, but not much. And I also want to point out that Judge Newman said, reminded the jurors before the trip, he talked today, and he said the vegetation is going to be different, the size of the trees is going to be different, the time of year is different. Just keep that in mind. And so he laid that down. So they will do that, and then mid-morning on Wednesday, they'll start up again. And I guess the closing arguments, and then he'll read what jury instructions come after the arguments. I guess
There'll be some probably a couple of instructions post. So he'll give a couple of instructions pre-argument about what the arguments mean, how a lawyer's arguments aren't evidence. They are allowed to give opinion, but it's their opinion. All that matters is what you applying the facts of the law, and so then they'll argue, and then he'll give the full instruction. And so tonight, tomorrow night, both sides are pulling together their proposed jury instructions. Judge Newman will review those. There'll be a hearing on that. Probably some fighting over what should or shouldn't be included, what special instructions should or shouldn't be included, and then he'll make a ruling, and then he'll give the charge, and then they'll begin deliberations.
So let's see. You got let's see. That's Wednesday. Do you think jury will be ready to roll Thursday? Everybody? Anybody want to take a guess or what they've heard? John?
4 to 5 weeks of testimony plus your rebuttal. You give an hour for each week of testimony, maybe.
Whew. Wait. You're saying that it's possible there could be a 5-hour closing argument by each side if there's 5 weeks?
I'm saying that there's been nothing about the presentation of evidence that shows that they are in a hurry, but they are focused on making sure the jury considers all the things that they put out there. And so I expect a incredibly long closing by the state. That being said, these guys, this is the shining moment of the prosecutor's career. This is the biggest murder case they will ever handle, ever. And the same for the defense. The defense will be thorough in their tearing apart of what they believe to be the state's case, but they are certainly going to, be at least 3 hours. I think all these guys have been proven they like to talk, and so I wouldn't be surprised to hear some long arguments, or because because of the stakes involved in the case. So but I think they'll still be compelling. But the old Toastmaster thing, the mind can only endure what the seat can, applies. And so you can just go too long, say too much, and lose the jury. And man, that's a silly reason to lose your case, but it happens.
Amen. That has happened. I feel like it's going on a little bit too long. I think editing is a good decision.
Well, hey, everybody, any last thoughts from Seton?
No, good night.
John Snyder, you got a podcast, I hear.
I do. We have a few episodes that will be launching next week called the Nerd Caucus. While I also enjoy talking about criminal trials, I love talking about politics. And this is not a political show. It is a show about kind of the backstory of, just like I was saying about the crime scenes, you got to go to the Capitol to really understand the history. And so we're going to talk about all the things that go into the pageantry, the procedure, and kind of the nooks and crannies of the federal Congress and the executive branch.
Awesome. And I never mentioned, but I do a little show called The Matt Ramona Show on Mix 107.9. So check that out in the mornings. All right, we're out. It's the Murdaugh Podcast on Facebook and MurdaughPodcast.com and MattHarrisPodcast@gmail.com. And we'll talk soon, friend.
And now another no-brainer money-saving tip from Progressive.
That doesn't sound good.
Paper shredder's jammed, but I think I fixed it.
Oh, well, try shredding these $50 bills then.
Seems like it's working.
Better try another $400.
Stop. Instead of using money, use regular paper. And here's a better tip from Progressive on how not to waste money. Don't pay too much for car insurance. Drivers who switch and save could save hundreds. Progressive Casualty Insurance Company and Affiliates. Potential savings will vary.
At Kroger, we want our fresh produce to meet your expectations, which is why we're dedicated to doing up to a 27-point inspection on our fruits and veggies, checking for things like scarring. In fact, only the best produce like zesty oranges and crisp carrots reach our shelves, because when it comes to fresh, our higher standards mean fresher produce. Kroger, fresh for everyone.
Save big on your favorites with the Buy 5 or More Save $1 each sale. Simply buy 5 or more participating items and save $1 each with your card. Kroger, fresh for everyone.